All right, good afternoon, everybody. I'm going to go ahead and kick things off. My name is Stan Odenthal. I am the Director of Business Relations for Heartland Workforce Solutions, and just want to welcome you this afternoon, this fun Thursday afternoon, to our HWS Better Business Workshop series. And so this is a series of workshops that we host for businesses. It's every third Thursday of the month at 1 p.m. We try and find engaging topics to help businesses grow and to help businesses thrive. And so today we've got a good one. We've got Lolly Sage from the Nebraska Department of Labor here to talk about staying in compliance with workers' rights in Nebraska. This last year, we actually did a similar presentation, and it was one of our most popular ones. There were lots of great questions. There were a lot of great conversation topics, and so hopefully we'll be able to do the same type of thing today as well. And hopefully this will get you engaged in this conversation of this very important topic. And so I just want to talk a little bit about HWS before we kick things off, and I hand it over to Lolly. As many of you know, HWS serves a 3-county area. It's Washington, Douglas, and Sarpy counties. And our mission is to promote and develop a workforce system that is responsive to the needs of businesses and career seekers, resulting in economic prosperity. So we're the federally designated workforce development area for those 3 counties, which means that we do receive those federal dollars to help train people, to help connect people with more skills and abilities, to hopefully create the best workforce that we can to meet the needs of businesses in our community, but also the needs of all individuals that are working or looking for employment. So we are that one-stop shop for businesses as well as job seekers. Our services are free. We've got 15 different partner organizations under our roof. And so we encourage you to look at our resources, check us out online at hws-ne.org, or come out and visit our location at 57th and Ames. Along with that location, we've got conference rooms that are available for free if you're interested in utilizing that space for your needs. And so I just want to make sure that you're aware of those great services. And so we've got other upcoming events when it comes to these workshops. Next month, SourceLink Nebraska will be here talking about some of the great resources they have for entrepreneurs as well as small business owners. And so with that, I'm going to hand it over to Lolly and let her begin her presentation. And as we do so, please feel free to raise your hand if you have any questions. I know that she's going to be taking a little bit of time between each of the sections to ask for questions, but feel free to put that information in the chat, any questions you might have, or just raise your hand. All right, Lolly.
All right, let me share my screen here quickly. Oh. Hello, everybody. Can you see my PowerPoint presentation?
Yep.
Okay, perfect. Well, like Stan indicated, my name is Lolly Sage. I am a bilingual labor law specialist for the Nebraska Department of Labor. And we deal with very specific laws for labor laws. And today we're going to talk about some of the ones that we get more questions on. If you want to write down this information for future reference, our general number for labor law is 402-471-2239. Our fax number is 402-471-5039. We do have 2 emails. The first email, ndol.laborstandardsinquiries@nebraska.gov. It's a little long and difficult. So if you wish to send us emails, even though it has nothing to do with contractor registration, to the contractor registration email, that's totally fine. And that will be ndol.contractorregistration@nebraska.gov. We are located in Lincoln on the east side of the Capitol building. So if at some point you wish to come, you are more than welcome. And okay, so.
Hey, Lolly, let me interrupt you like 1 minute into your presentation already. So I forgot to do the polling question, which I think would be helpful. So let me do that real quick.
Okay, should I stop sharing?
No, you're fine.
Okay.
I'm going to launch a polling question. We're just interested in what industries are represented on this this meeting. And so if you wouldn't mind answering that question, it just helps Lolly as she's putting, having these conversations with you, understanding who's in attendance and what industries are represented. So just take a minute and answer that. Okay, cool. I'm going to end the poll now. It looks like we've got quite a few people from healthcare and retail or hospitality, and then quite a few from the nonprofit world. So hopefully that helps you.
Yep. Okay, so so it seems that we don't have anyone in construction today. So I will go very quickly through the Contractor Registration Act and the Employee Classification Act. Honestly, the one that we get more complaints on and questions and concerns will be the Wage Payment and Collection Act, but I'm going to start with that one. So today we're going to talk about Wage Payment and Collection Act, Contractor Registration Act, Employee Classification Act, child labor law, and lunch period law. Honestly, they're very short statutes. So most likely we're going to spend most of our time in Wage Payment and Collection Act. If we have time at the end and you wish to go back with the Wage Payment and Collection Act, I'm totally fine with that. So let's start. Nice, here it is. Okay, so the Wage Payment and Collection Act is a Nebraska revised statute that goes from 48-1228 to 48-1230. Hold on. Okay, and the Nebraska Department of Labor is responsible for the enforcement of this statute, and is part of the administration. We are part of the administration of the WPCA, or Wage Payment and Collection Act. We receive complaints and we follow up with these complaints. Anyone that has worked as an employee physically in the state of Nebraska and believes that they are missing wages, shorted wages, they haven't been paid a check or the last check, they all have the right to file a wage complaint, and this is a free service. And okay, so. And like I was explaining, everyone has the right to file a wage complaint. However, we only have jurisdiction on employees or former employees. I'm saying this because if you, let's say, are a contractor that the company that contracted you is not paying you the money that is owed to you, we technically do not have jurisdiction on that, because that will be a situation from company to company, not from employee to employer. And like I was saying, we only have jurisdiction on work done physically in the state of Nebraska. And I'm saying this, sorry, because sometimes we receive phone calls or complaints, like, for example, the company is physically in Nebraska, but they are working in the state of Texas or something like that. We wouldn't have jurisdiction on that. Also, for example, like truck drivers, that they drive every truck driver is different, but we get sometimes complaints about truck drivers that drive all around the US and not only Nebraska. If that would be the case, we refer them to the Federal Department of Labor, which they have jurisdiction on all the states of the United States. And we do have a statute of limitation of 4 years to investigate a possible violation of the WPCA, or Wage Payment and Collection Act. So what is the definition of an employer? Is basically the state or any individual, partnership, LLC company, association, joint stock company, trust, corporation, political subdivision, or personal representative of the state of a deceased individual, or the receiver, trustee, or successor thereof, within or without the state, employing any person with the state as an employee. Usually an employee basically are taxes taking off their checks, and usually they get a W-2. And basically, and an employee, the definition under the Wage Payment and Collection Act is an individual that is permitted to work for an employer, to have an employment relationship or a contracted relationship to sell goods or services for an employer, and to be compensated by commission. And the definition of commission here will be like wages too. Okay. So under the Wage Payment and Collection Act, employers have to set regular pay days to pay all the wages due to that employee on those days. So if you're telling, if you tell your employees you're going to be paid every Friday or the 1st and the 15th or the last day of the month, you need to stick to that. If at some point these dates of payday are going to be altered, there needs to be a 30-day prior written notice to change this payday. On every payday or every paycheck, the employer has to provide or make available pay stubs, which is basically a wage statement. And I'm saying provide or make available because it doesn't say, the Wage Payment and Collection Act doesn't say that with a check you have to give them the pay stub, but at least make them available. There are some employers that have them available in an online portal, or you can also make them available per request. But the employee has the right to know the amount of hours that they're being paid, at which rate of pay, which deductions, the employer that is paying them, and also the pay period that they're being paid for. Under the WPCA, also final checks. So after a separation of employment, final checks are due on the next payday after the separation or within 2 weeks, whichever comes sooner. Otherwise, the employer is in violation of this act. And well, like I was explaining, pay stubs need to be available on every payday. Make them available or provide them to them by email, electronically per request. And under the Wage Payment and Collection Act states that at minimum, this wage statement has to include the identity of the employer, so the employee knows which company is paying them, the hours which the employee was paid, the wages earned by the employee, and any deductions that were made for the employee. Fringe benefits. Fringe benefits is basically, like the word says, is a benefit that is offered by the employer. Fringe benefits include sick, vacation leave or PTO, disability income protection plans, retirement, pension, profit sharing plans, health, and accident benefit plans, and any other benefit that the employer provides or makes available to the employees that they want or do not want to be part of. Under the Wage Payment and Collection Act, the definition of wages basically is the compensation of labor or services rendered by an employee, including fringe benefits when previously agreed to and conditions stipulated have been met by the employee. For example, a bonus. For example, so a bonus is a fringe benefit that the employer doesn't have to offer, but if they offer, they have to, and the employee meets the conditions to get this bonus, it's payable and becomes wages under the definition of the Wage Payment and Collection Act. And I'm saying conditions because, for example, sometimes they say for you to get this bonus, you have to have I cannot think about an example right now. For example, you have to have zero, like you have to be on time for a month at work, and then you are eligible for this after a week of that month pass or something like that. Well, under the wages, like I was mentioning, It also includes commissions. Determined is on a time, task, fee, commission, or other basis. A paid leave or PTO or vacation, other than earned but unused vacation leave provided as a fringe benefit by the employer shall not be included in the wages due and payable at the time of separation, unless the employer, the employer, or the collective bargaining representative have specifically agreed otherwise. So basically, paid leave, there will be two. That will be vacation leave or PTO, and then sick leave. Under the Wage Payment and Collection Act, vacation leave or PTO is payable at the end. I mean, we have technically only jurisdiction to investigate vacation and PTO leave when is due when there is separation of employment. However, and those are payable and become wages under the definition of the Wage Payment and Collection Act. However, sick leave is not payable unless it was agreed upon that, or the employer has a policy that sick leave is paid fully, or I don't know, if you have only 25% of the accrued unused hours of sick leave that the employee had at the time of the separation.
I've got a quick question for you on that,
Yes.
Lolly.
Yep.
So a lot of companies now they're starting to go to kind of an unlimited leave or a freestyle leave where you're not necessarily going to get a payout coming out from that because you don't have a accrued leave. It's more of a flexible schedule type of thing. Are you guys getting complaints about that from anybody that's separating from employment, or have you seen any of that yet?
Yes, I've seen it. We haven't gotten that many, but yes. And the issue with that is, like you were saying, is indefinite. So at the time that you're employed, they make it sound that you can use as many PTO or vacation or leave as needed. However, like you were mentioning too, you technically don't accrue it. So technically at the time of the separation, there's no accrued unused PTO, and we cannot ask the employer to pay those wages, basically. Does that answer your question?
Yeah, it does. It's one of those things that's becoming more and more popular. And so hopefully those employers that are doing that are putting that into the new employee orientation that's, hey, there's not a payment at the end of things, because you're not technically accruing any hours, but it's awesome while you're there though.
Correct. So, I mean, there's only employers here today, but I would, as an employee, I would always recommend to really read thoroughly the policies, especially because sometimes we get like a complaint like, oh, you have unlimited PTO. It's like, I have unlimited, so I'm owed 1,000 hours. And it's like, no, really, because if you review the policy states so and so and so, so technically we cannot ask the employer to ask his hours. And every policy is different. Again, this is a fringe benefit. So if someone files a wage complaint, one of the first things that we are going to ask is for the policy. So as an employer, I strongly recommend you to have this policy in writing, so it's clear for the employer, for the employee, and it's clear for also the department that is going to potentially investigate this allegation. So everyone is like on the same page. Okay, we're gonna keep going. But like I was indicating, if you're going to alter the paydays of the employees, the employer has to give a 30 days written notice to the employee before they change the usual days that they're going to be paid their wages. An employer may deduct, withhold, or divert a portion of an employee's wages only when the employer is required to do so by state or federal, like taxes, or maybe there's a court order because there's like a garnishment, or maybe there is child support that is due. And then, or the employer has a written agreement with the employee to deduct, withhold, or divert. Otherwise, the employer cannot make any other deductions. For the second part, the written agreement with the employee, sometimes, I don't know, the employee lost, I don't know, something from the employer, the employee and the employer agreed that they were going to deduct $25 for every check until this amount is paid, or something like that. Otherwise, the employer technically cannot do that. And in that case, I will recommend employers to have everything in writing, especially if someone files a wage complaint. And wages of an employee cannot be dropped below minimum wage. The minimum wage in Nebraska is $9 per hour. This is very important to mention because sometimes, so you can technically drop them below. So you have to pay them at least $9 per hour gross. But then obviously with state and federal taxes is going to be dropped a little bit below $9 per hour. But for example, sometimes I've seen like some policies that the employer is like, well, if you don't get here on time, we are going to deduct this amount of your wages. And if that amount drops them below minimum wage, that goes against the WPCA. And we will ask the employer to basically they cannot do that. Or sometimes the employee is already earning $9 per hour, and then the employer has this policy that if you don't get in time, they're going to deduct, let's say, 10% of your wages. I mean, that means that you're already dropping them below minimum wage. In regards of commission, if like you are purely a commission employee, and let's say that I sell, I don't know, my machines in general, and let's say that there's like a week that I didn't sell anything, or I didn't sell much. In that case, the employer has, even though you're 100% commission, the employer at least has to make sure that you are paid $9 per hour. And this is very important. An employer shall not retaliate or discriminate against an employee because the employee files a suit or a complaint under the WPCA, or testifies, assists, or participates in an investigation, proceeding, or action concerning a violation of the act. If, let's say, someone files a wage complaint while they're still employed, because they believe that in the last 2 paychecks they were shorted some hours on the pay stubs, the employer cannot retaliate against this employee. And if the employee is retaliated against, we do not investigate those allegations. Those are with the Equal Commission, the Nebraska, how do you call it? The
Nebraska Equal Opportunity Commission.
Yes, thank you. Yes, yes. Okay, so how this process works with a wage complaint. So like I was saying at the beginning, anyone that has worked as an employee in the state of Nebraska and believes they are missing wages, they have the right to file a complaint. To file a complaint, it's done online. Here in the next slide, I'm going to show you how this looks. Here is the link. Basically, the easiest way is to go to dol.nebraska.gov, click on labor law, and labor law, I don't remember if it says labor law, labor standards, because they changed it. Then click on wage complaint, and then click on file wage complaint, and then you will get the form. Once that someone fill out all the required fields and submits it, an email is going to be, the complainant, the individual that filed the complaint, is going to receive a confirmation email. And then this complaint is going to be assigned to an agent who is going to contact first the employee within 1 to 3 business days from the date that the complaint was initially filed. And then we give 3 business days to the complainant to reply. Once that the the complainant replies to our initial email or initial phone call, it just depends, every case is different. We will reach out to the employer. If we have an email, we will send an email to the employer and a letter in the mail. It's basically an initial request where we are requesting, when we are telling the employer, well, this individual filed a wage complaint indicating that they are owed this amount of wages. Please provide this documentation for us to investigate and make an accurate determination on the matter. However, if you believe that this individual is owed this amount, please pay. And there, every case is different. There are some employers that they file a wage complaint, the complainant files a wage complaint, we reach out to the employer and they just pay because the employer knows that this individual is owed wages. Or sometimes they agree wages are owed, but they are not the amount that the complainant is saying they're owed. So that's especially when we will need the documentation for us to determine what is the amount that this individual is owed or not owed. Once that we reach out to the employer, we give the employer five business days. If they don't reply by the provided deadline, that's when we reach out to our legal department and we issue a subpoena, where is basically commanding the employer to provide the requested documentation. And if the employer, at the end of the day, regardless of who provides the documentation, we are not judges and we can only make a determination based on documentation available, especially if it's a he said, she said type of situation. If after investigating, after receiving all this documentation, we determine that the individual that filed a complaint is owed any amount of wages, we will give the opportunity to the employer to pay this due wages. However, if the employer doesn't pay those wages, that's when we have to issue a citation for violation of the Wage Payment and Collection Act, which a citation is public information. So if you go to our website, dol.nebraska.gov, click on labor law or labor standards, you will find there which are the employers that have unpaid outstanding citations. And like I said, this is public information. And I think I'm missing something here. Oh, but yeah, if the employer pays the wages, we don't really issue a citation against the employer. It's very important to mention that a citation can be appealed, but a determination cannot be appealed. So a determination is, that's our determination, that's definite, but you either pay or do not pay. You cannot appeal that, but if we issue a citation, you can appeal that, and then a hearing officer can hear again your case, and then they will basically agree with the determination that the agent issued or do not agree. And well, this is, it's in 2 different slides, I'm sorry. This is how it looks, the wage complaint from the top part. So basically, at the beginning is just some personal information and then business information. We usually, when we send the initial letter to the employer, we usually go based on what the employee provided to us. So sometimes they will give their, and I'm saying this because sometimes they provide the name of their supervisor. So that's the only name that we have. So we address the letter to the supervisor and for HR or payroll. And then sometimes, depending how big the company is, sometimes that individual reaches back to us, or sometimes this individual just passes this letter to their HR or corporate or payroll, whoever proper party, and then that party can reach out to us. And then this is how the last part looks like. So it's basically employment information, when you started, when you ended, did you quit, did you discharge, what was the situation, and how much you were paid, either by the hour or however you were being paid. Some people were paid just like commission or annually or monthly, and then the wages that you believe that you are owed. And then here we have an area for explanation where they can tell us a little bit more about this allegation, and then their electronic signature, and then they can submit it. And that's when they submit, that's when they should receive a confirmation email where they are told that they're going to be contacted by an agent within 1 to 3 business days. Okay, so before we jump into launch period law, do we have any questions for the Wage Payment and Collection Act?
I'll hop in with the question, and feel free to add questions to the chat as people have questions. So you mentioned when there are complaints and it goes through that process of determining whether the complaint is valid or not. Once that determination is made, does that information become public? Is it posted on the website of like
No.
employers? Okay, it's all.
No. Yeah, it's only public when there is an outstanding unpaid citation.
Okay.
Mm-hmm. Any other questions? Okay. Well, if something comes up, I'll answer then. That's okay. So the launch period law, it's very short, and it's the Nebraska revised statute that goes from 48-212 to 48-213. And basically the launch period law states that for every 8 hours, for a shift that lasts 8 hours, the employee needs to be given a 30-minute unpaid lunch. However, this is only applicable for 3 very specific industries: assembling plants, workshops, and mechanical establishments. On this 30 minutes, the employee cannot be asked to do any job or work for the employer, and they cannot have him stay in the building or premises of the employer. So basically the employee should be free to leave for those 30 consecutive minutes. An employer that violates this statute shall be guilty of a class misdemeanor 3. However, this lunch period law also states that for example, let's say that I work from 8 to 4:30 with a 30-minute unpaid lunch, and I work at a factory and where we assemble, I don't know, a mower or something like that. If the employer can offer the employee to not take those 30 minutes and leave instead of 4:30 to leave at 4. The employer can do that as long as the employee agrees to it, and there has to be a written agreement in between both parties, and that is okay under the launch period law. We get a lot of complaints sometimes on the phone saying that they work for a grocery store, that they work a 6-hour shift and they're not being given lunch, a 30-minute lunch. Unfortunately, there's nothing that we can do about it. In that case, a lunch will be more like a benefit if the employer wants to provide it or not, unfortunately. And in Nebraska, we do not have a law that talks about breaks. So 15-minute breaks, that will be also like another benefit provided by the employer. It's very short, the launch period law, and this is it. Does anyone has any questions about launch period law?
We do have a couple of questions here in the chat.
Okay.
one of them mentions that we work with a lot of folks on unemployment, and we are always wondering where to send folks or what resources to give if someone claims they were wrongfully terminated.
Unfortunately, in Nebraska, there's no wrongful terminations under labor laws. I'm going to go a little bit with unemployment. I don't work for unemployment, but I do have a little bit of knowledge. However, under Nebraska labor laws, Nebraska is a state that is at will, meaning both parties have equal right to end the employment relationship at any time and for any reason. However, unless there's any type of discrimination on harassment on behalf of the employer, but we wouldn't investigate that. That would be with the Equal Opportunity Commission.
Yeah, and let me just speak a little bit to that, because I do have some experience working with the Equal Opportunity Commission. And so with that, if it is related to employment discrimination, or if they feel that it is something related to employment discrimination at all in any of those aspects, then you can always file that statewide with the Nebraska Equal Opportunity Commission. However, you can also, if you're in the Omaha area, you could directly file with the Omaha Human Rights and Relations Department. Or if you're in the Lincoln area, you could file with the Lincoln Commission on Human Rights. But any of those organizations would be the starting point for that.
Oh, I didn't know that. Well, I mean, besides the EOC. Thank you, Stan. So yeah, under like sometimes we receive calls that I was wrongfully terminated. Unfortunately, there's nothing that we specifically can do about it, because you can let go an employee at any time. You don't have to give them any reason, just like the employee can walk off the job and don't give you any explanation, basically. And then just to clarify, with unemployment, it's a little bit different. Unemployment, they do investigate what was the separation reason, if it was a quit or if it was a discharge, to determine if they are eligible for unemployment. But that will be specifically only for unemployment. And depending the separation reason, they would be the complainant, the claimant would be or not eligible for unemployment, basically. Long story short.
Then there was one more question in the chat. Where can employees access that form again for wages not paid? Up on your website, right?
There's two ways to get to the application form. For me, the easiest way is to Google Nebraska Department of Labor wage complaint. Everything just like that. Please don't do NDOL. So do the whole name of the Nebraska Department of Labor wage complaint as the first link that you are going to see. Click on the link, which is going to take you automatically to the application form. However, if you wish to go to our website is dol.nebraskaspellout.gov. Click on either labor law or labor standards. And I'm saying this because sometimes they change it. And once that you are in labor law and labor standards, under worker rights, it says wage complaint. So you click on that button and then click again on file wage complaint. Either way, you're going to get to the application form. Okay. Any more questions? Okay. So if there's any more questions, we can address them later. Okay, so I know that there's no contractors here today. I'm just going to, but I don't know if the nonprofits that are here today help contractors with the registration. I'm just going to talk very quickly about this. So basically, the Contractor Registration Act is a law in Nebraska that requires that all contractors and subcontractors doing business in Nebraska to register with us, with the Nebraska Department of Labor. And with this specific law, a contractor is basically any person who engages in the business of construction, includes subcontractors, general contractors, and any other arranging for the performance on work on real property. So basically, I'm not talking about contractors that maybe I'm an ABC Inc. and I need a marketing company and I hire that contractor to do my advertising. We do not have those are not the contractors we're talking about. It's more like in the construction business. So if you are modifying, building real property, you are a contractor. There are some companies that they don't technically do the construction work themselves. However, they arrange contractors or subcontractors to do the job. If that would be the case, even though they're technically not doing the job themselves, they also need to be registered under this act. That goes from the Nebraska Revised Statute 48-2101 to 48-2117. There is for Nebraska contractors, there is a $25 annual registration fee. However, if you are not, if a company has only one owner or is self-employed, and I'm saying one owner because you can be an LLC with just sole proprietorship, and you have no employees, or you have employees but you don't pay more than $3,000 annually, we give you the option to waive this $25 fee. If you wish to waive this $25 fee, you will have to print an affidavit, which you're going to be given the option to print the affidavit, get it notarized with a notary, and then get that to us, and you wouldn't have to pay this $25 fee. With out-of-state contractors is a little bit more difficult. A little different. They do have the same $25 annual registration fee, plus a one-time fee. So if I'm let's say I'm a new contractor from Colorado that I'm coming for the first time to work in Nebraska, the first time at least this individual is going to be charged $50 unless they meet the conditions for the waiver. At least it will be they will be charged for $25, the one-time fee. And out-of-state contractors are also required to pay a $25 project permit fee for any projects that are over $10,000. So if the project that I'm going to do in Nebraska, I'm going to be paid more than $10,000 for that project, I need to issue and pay for this project permit fee. And out-of-state contractors are also required to have a registered agent in Nebraska, so with a Nebraska address, in case that we cannot get a hold of the contractor. Basically, they're giving the right to this company or this individual to contact them regarding their registration or their business. What happens if, I didn't mention this in the WPCA and the Wage Payment and Collection Act. The first violation and it's the same with the Contractor Registration Act. So if we see that there is a violation of the act, the first violation is only $500, cannot be more than $500. It's the same with the Wage Payment and Collection Act. However, if we find that there is two or more violations, the citations can be up to $5,000 per violation, or in the case of the Wage Payment and Collection Act, per complaint, so per individual, per complainant or employee. Under the Contractor Registration Act, all general contractors are required to review that all the subcontractors that they're hiring are registered and in compliance with the contractor registration. Otherwise, the employer has to basically withhold and remit 5% of all the payments to that subcontractor, and submit that or refer that to the Department of Revenue. Once that subcontractor is in compliance with the Contractor Registration Act, this company, this individual, or this contractor can contact the Department of Revenue to get that 5% back. And just quickly, this is how our website looks like. So all contractors that have a profile, they log in or they create a profile. If there's a new contractor, we do have a public database, which it's over here. It says search contractors. the public can click on this button, and let me show you here. And this is how it would look when you click on search contractors. You can search here any contractors to make sure that they're in compliance. All the contractors that you find in this website or in this database, that means that they're in compliance. You don't have to look them up entering all the fields. With one field is more than enough. Sometimes we receive phone calls like, oh, this contractor gave me their registration number, but I cannot find them in your database. If that's the case, I recommend you to give us a call, and we can give you more information, because sometimes the contractor is registered, maybe it's not in compliance. And when I say in compliance, maybe the registration expired and they haven't renewed, or maybe they indicated that they were going to send us the affidavit and we haven't received it, or they said they were going to send the payment on the mail and we haven't received it, or maybe we are missing a certificate of workers' compensation. That's very important. I think I haven't mentioned it. Under the Contractor Registration Act, any contractor, any company that has one or more employees, even if it's part-time, they're required to carry workers' compensation. And if, let's say, they are reporting that they have 2 employees and the certificate of workers' compensation that we have on file expired, basically, they wouldn't be in compliance. So we will ask the contractor to provide a current certificate. And this is basically, in general, the Contractor Registration Act, which I'm going to talk about the Employee Classification Act, because they're technically a little, they go together. But before I move forward, does anyone have questions about the Contractor Registration Act? Okay, so under the Contractor Registration Act, we as investigators also have the right to do on-site inspections. So basically, we drive around Nebraska, and everyone has a section, and we drive around Nebraska, and when we see a construction going on or a modification going on, we stop and we have the right to investigate. If, like, for example, because sometimes, and this has happened to me, sometimes they are doing tree trimming in the backyard of the house. Sometimes they want to tell us that we're trespassing, but under the Contractor Registration Act, we have the right to be there, ask questions to the workers, and take pictures to investigate possible violations of the Contractor Registration Act and the Employee Classification Act. The Employee Classification Act basically is a law in Nebraska that provides protection to workers, however, only in 2 industries. It will be in the construction industry and in delivery services, from misclassification as subcontractors for the purpose of tax withholding, unemployment insurance, and workers' compensation insurance. There's a lot of contractors, to my experience, like in the construction industry, that they, especially with roofers, because to my understanding, they have the workers' compensation. It's the most expensive because, I mean, makes sense. It's like you're working on a roof. So there's a lot of contractors, general contractors, that misclassify their employees as contractors or subcontractors, so they don't have to pay taxes, unemployment benefits, and workers' compensation for their employees in case that their employees are injured. That's one of the reasons why we request to the contractor to provide to us a certificate of workers' compensation when they indicate that they have any amount of employees, or when we find them in a construction inspection, like the ones that I was mentioning. What is, just in general, the definition of an employee, because that gets a little tricky sometimes, or people get confused. Sometimes they say, oh, I'm a 1099 employee. Well, on the ECA, under the Employee Classification Act, if you're an employee, you should get a W-2. So what is the definition of an employee, or what's the difference of an employee against a subcontractor? Basically, an employee does not own and operate his or her own business. Taxes are taking off their checks, and they get at the beginning a W-4, and then at the end of the year or the following year a W-2 to do their taxes. They're not registered with the Nebraska Department of Labor as a contractor. They do not have the freedom to choose which jobs they want to do or to accept. They don't have the freedom to hire anyone they want to work. If they need help, they cannot just hire anyone they want. And usually they do not provide tools and materials to perform their work. So basically, an employee is told what to do and when to do it. As a difference, I don't have it here. A subcontractor is basically a subcontractor owns and operate their own business, meaning they are a business independent from the contractor or the other business that is hiring them. A subcontractor must be registered with the Nebraska Department of Labor. Taxes are not taking off their checks. Usually, a contractor gets paid by the job. And an employee gets paid by the hour, usually. And a subcontractor has the freedom to choose which jobs they want to do, and also have the freedom to hire anyone they need in case that they need help. And usually the contractor has their own tools. The materials is a little bit different because sometimes there's like a general contractor who provides the materials, but that's a little, every construction site is different. And just like the CRA and the WPCA, if we find that there has been a violation of this act, we can issue a citation up to $500 for the first offense per misclassified worker. So if we go to an on-site inspection and we find 10 individuals that at the moment the contractor was saying, oh, no, they're my subcontractors, we do an investigation for possible violations of the contract of the ECA, and we find that those 10 individuals that were at the location were actually employees that were being misclassified, the contractor is going to be issue a citation of $500 per worker. If there is a second offense or more offenses, it's up to $5,000 per worker. And this is very important. Any contractor that has any unpaid fines for violation of the ECA and also WPCA shall be barred from contracting with the state or any political subdivision until such fines are paid. And this is also public information. Sometimes we have other state agencies that reach out to us because they want to verify that these employers do not have unpaid citations. And any questions about the CRA or the ECA? Okay. And now the last law is also pretty short, is the Nebraska Child Labor Law. And is the Nebraska Revised Statute 48-301 to 48-313. This law indicates that kids or children that are 12 years old or under shall not work in the tasseling or any job unless their parents own the business. So if I'm 11 years old and my parents own a restaurant, I can work. But if my parents are not the owners, I cannot work if I'm 12 years or under. 13-year-olds can work in the tasseling, but that would be the only industry under this law that they can perform. 14 and 15-year-olds, basically they have some hour restrictions. They can work from 7 a.m. to 7 p.m. I'm sorry, they cannot work from 7 a.m. to 7 p.m. During when they're in school, when they're like in school season. They can only work 3 hours on a school day, but if there's no school or if they're on vacation, they can work up to 8 hours on a day. And if they are on school, if school is in session, 14 and 15-year-old cannot work more than 18 hours in a week, or they can work for up to 40 hours in a non-school week. For 14 and 15 years old, we do have a work permit that is required by this law. And the individual, the minor, must have a job offer prior issuing this work permit. So let's say I'm a fast food company. I'm a 14-year-old. I go to an interview. I get hired, and then I have to. I'm going to show you how this looks, but you can get a blank copy of this work permit in our website too. You can print it, either the company or the minor, or the parents of the minor, or the school that the minor goes to. And the first part, let me see. So here it is. So the first part this part of the employment certificate needs to be filled out by the minor. And then the last part, the certification part, has to be signed by an issuing officer of the school that the minor goes to. An issuing officer is basically a representative from the school that the minor goes to. For example, the principal or a counselor or the secretary. And then once that is filled out by the minor and is signed and approved by the school, either the minor, the school, or the employer have to send us a copy. We don't have to have the original. If you don't hear from us, that means that everything is okay. If you hear from us, it's because we have questions, or because there's something missing, or because we think that maybe the minor is going to be in a hazardous situation. We don't determine if a job is hazardous or not for the minor. That is determined by the Federal Department of Labor. But for example, a 14 and 15-year-old, under these laws, they cannot technically operate or work around a power-driven device like or machine like a mower or something like that. And over here in the employment certificate, you can also see the hour restrictions. I know here it says federal hour restrictions and Nebraska hour restrictions. They're a little bit different. However, since the Federal Department of Labor has more regulations, we always go with federal regulations in regards of child labor laws. And 16-year-old or older minors can work without any hour restrictions at any job, as long as it's not hazardous. As I was saying, for details regarding what is hazardous for a minor, you will have to contact the Federal Department of Labor. And we, under the child labor law, we also have a Nebraska, the performing arts. So basically, this is minors that, I don't know, they're like models, or they work work at a play, they're actresses and actors. If that's the case, there's like a different form that needs to be filled, and this one has to be approved by the Nebraska Department of Labor. And there's a $10 fee. The other one is for free. However, this special permit basically waives the hour restrictions that I just mentioned. And however, this permit expires 90 days after it was issued. And this is also available in our website. This is a little bit how it would look like. And needs to be signed by, fill out by the minor, and then signed by the parent or the guardian. So this basically is in general the main laws that we deal on a daily basis. We have other laws like farm labor and stuff, but that's a little bit different. Do we have any questions of any of the laws or anything that I mentioned here today?
So we'll give it another couple seconds. If there are any questions, either raise your hand or put the info in the chat.
Okay. You know, if right now nothing comes to mind, any questions, you can feel free to give us a call or send us an email. We're very good at replying those questions via email or phone, whatever is easiest for you.
All right. Well, sounds good. Thank you so much, Lolly, for this information. Incredibly valuable information. I'm glad we had a few questions along the way.
Mm-hmm.
And so, as always, we encourage everybody to attend these future events the third Thursday of each month. So next month, again, is SourceLink Nebraska on April 21st. Thank you again, Lolly, and hope everybody has a great Thursday. Talk to you later.
Thank you. Bye.